start by saying thank you to ELA and the International Law Society for co-hosting this lecture and for providing the food for our enjoyment here, and for our online audience. Look forward to having a discussion on this important cutting-edge topic. And I think it's particularly relevant that this event is co-hosted by the Environmental and Energy Law Association and the International Law Society, because one of the themes of this lecture, and in fact the course that I'm teaching this semester on human rights and environmental protection, is that these two fields need to work together more effectively in tackling a crisis like climate refugees, climate migration. So let me give you a little kind of context here for what we're going to be discussing today. Before we dive into the refugee problem itself, it's good to set a kind of common foundation for where we are on climate change and the issues that are driving the climate refugee crisis. So really the first step is the science, which has been crystal clear for a long time. Even the climate denial movement is essentially given up trying to dispute the certainty of the science on climate change and the projections that are being made near term and long term for the consequences that flow from the climate crisis. And essentially, to oversimplify to a painful degree, the next 50 years are projected to be ones that will have devastating consequences for all corners of the earth, but in particular, more vulnerable places on earth. And that sometimes means nation states, for instance, the South Pacific or South Asia or Africa. And in some instances, it means particular communities within those nations, such as indigenous communities and other overburdened communities in society that typically bear the brunt of climate change impacts before the rest of us do. So that's one foundation that is indisputable in how this crisis is unfolding now and will simply get worse as we move into the future. And the other reality is that what's really propelled the climate crisis is not showing any real sign of changing by next week. And that's our global fossil fuel addiction, whether we're talking about the developed or developing world. That's really what's driving the climate crisis, and an example of how we're just not where we need to be on that. There hasn't even been a global commitment in principle to phase out fossil fuel use. So when I attended the COP26 in Glasgow, there was a very close to an agreement that fossil fuels should be phased out and a target for that. And then very late in that process, the language was changed from phase out to phase down, which is not nearly where our ambition needs to be if we're going to have any kind of handle on stalling those inevitable crises from climate change this year. The phase out objective needs to be front and center as soon as possible. Interestingly, though, that connects to the North-South divide on these issues. So the reason why the phase out language didn't make it was because major developing countries and economies in transition like India are very coal dependent for their energy supply. And that's understandable. We certainly aren't blaming them for having that reliance on coal. That was really a product and a function of the colonial influence that from the West, that there is that reliance in a country like India on coal. So that's where our effort to address climate change on a global level hasn't worked as effectively as it should. And that notion is what's called common but differentiated responsibility, that we have this global problem, but we have different levels of engagement in how to address that global problem. So the global North is supposed to take the lead on funding and technology transfer to the global South. And that challenge in India should be something that we can overcome as a global community with that funding and technology transfer. And that hasn't worked nearly as well as it needs to when we look at global climate governance over the past 3 decades. So one of the best illustrations of that is that the reality is indisputable that the climate change impacts the developing world is experiencing are largely a product of how the developed world got out ahead in developing their economies with the consequences on the planet, and again, disproportionate burdens from those consequences in the developing world. And there was an effort over a past decade or so to establish some kind of accountability in the global north, that they're responsible for the majority of these consequences we're experiencing now. And so an effort was made to have some kind of loss and damage responsibility imposed on the global north for their significant contribution to those impacts. And that was categorically resisted. The global north didn't want any part of that. Even if they recognized that they really propelled this crisis, they were not willing to ultimately be accountable and pay damages for the losses happening outside their borders in the developing world. So that's a real failure of moral and legal responsibility, and that persists. And of course, that is accelerating this unfolding climate refugee crisis that we're witnessing. So this is really important to remember. The climate refugee crisis is just one aspect of all of the human rights consequences that are starting to unfold from climate change, but that's the focus for today's talk. Just want to remind you that this is just one of many human rights dimensions to climate change. And what's really challenging about the climate refugee, climate migration crisis, though, is that it's driving potential conflicts that could be very, very significant, well beyond determining where people should live. It could really propel major political and even military engagement to address how these issues will ultimately be resolved. When we're talking about people getting forced from one country and crossing a border into another, that's very much like a military invasion. It's not consensual. It's done out of necessity, and ultimately, you're crossing the border where you aren't welcome. That often will cause very significant repercussions. So that's what we're looking at, that climate change is this threat multiplier for all these existing tensions that were already there in the world, all the political and cultural tensions on borders that we see around the world. That's going to get exacerbated to a very serious degree as climate change continues to unfold. And the climate change refugee crisis is one example of that. So I think it's important to understand that as I started the lecture, there's really two fields that ought to be very much involved in trying to have a solution for climate refugees. And I think that one of the biggest challenges we're facing right now is that neither field is taking the lead. When we look at international environmental law and international human rights law, both have some role to play in addressing the climate refugee crisis, but neither one embraces this crisis as their own. So international environmental law has been traditionally more about regulating problems in this political and scientific way to manage some way in which we're impacting the Earth's systems and trying to reduce our impact on it. Whereas international human rights law has been a separate domain that has more of a traditional sphere of coverage that includes refugees, but not climate refugees. And we'll talk about that later, how the concept of refugees in international human rights law is a very different understanding than what we see with climate refugees. It's a very different category of displacement and migration. So it's also important to understand how quickly this crisis is unfolding with nobody taking the lead on it. So when I started to give this lecture in 2015 or 16, the UN agency for refugees really had its head in the sand so much that there was nothing on its webpage about the challenge of climate refugees. And here we are just 5 to 7 years later from that time when I started to look at this issue. And now it's really a major focus, which is promising. At least there's more awareness and coverage of the issue, but the action has simply not happened yet. And that's where the crisis is. Getting the talk started is a good first step, and we'll talk a bit more about that today. That's far better than ignoring it entirely, but neither of these fields is embracing this as its responsibility. So when you think about climate governance and you attend one of these global meetings called COP, the Conference of the Parties on Climate Change, climate refugees discussions is at the bottom of the list if it exists at all on those agendas. There are many more priorities that those meetings address in their mind that don't include climate displacement. So the other reality is how quickly these challenges have unfolded in terms of the science and the realities of climate change impacts. An atmospheric river just hit California relentlessly this year. I mean, that was something that was not on my radar. I've been in this field for 3 decades now, and each year, bomb cyclones, that wasn't in my vocabulary of what the atmosphere does in my entire life until about a decade ago. So everything that's causing climate change, the only thing that we know for sure is it's gotten worse and it's going to continue to get worse in a way that's going to be very unmanageable very soon. And we can anticipate that this is going to cause mass migration. And we have to get ahead of that challenge. We cannot simply let this unfold in a social Darwinism sort of way, and the politically and economically powerful will find a way to adapt, and the rest will perish. That's a future that could be happening in decades if we don't get a handle on this. So this notion of a legal void is important to understand that the scope of the crisis first. I mean, that number is likely conservative. I think there's been one common theme in climate change projections and what's going to happen in the near and long-term future. They're almost always too conservative, is what I've witnessed over the past few decades. So this projection by a reliable source down the street, the World Bank, 200 million people by 2050 displaced by climate change factors alone. And that is 20 times the global population of current refugees around the world. That's pretty shocking. And again, that's probably conservative. It's probably going to be higher than that based on what we've seen and trying to project what climate change is going to do over the past few decades. And there's absolutely no legal framework in place to address this, knowing that those are the consequences that await us. And still here in 2023, no legal framework in place. And so this idea of the legal void has only moved forward incrementally, I'd say, over the past decade. The discussion of climate refugees isn't really happening in an urgent, robust way at the international level. Some pockets of interest have unfolded more out of self-interest, really, than anything else, about preparing for the climate displacement crisis. And many of those vulnerable nation states have tried to take matters into their own hands about trying to ensure that they have a place to go when their home is no longer habitable. And those have not done very well in terms of securing those sources of future relief in terms of transitioning from a homeland. So I'll talk about some ways in which the law has tried to address that, largely in the courts, and that hasn't gone so well either. So I think it's important to start with, when we have this conversation, terminology. Who are climate refugees? That may seem self-evident initially, but there are some nuances that we really need to dive into a bit in thinking about what we mean by this term, and if this term is in fact the appropriate or respectful term to use when there are other terms available. And so then I'll take you through a couple of case studies, both in the US and at the international level, where there have been threats of climate displacement, how the law tried to respond and failed to respond, how this is a quintessential human rights issue, and how seeking relief for the threat of this near-term reality is nearly impossible right now with the way the existing framework is in both the US and the international levels. So I try to end optimistically, which is always hard in this field, and try to offer some ways forward, possible avenues for addressing the issue in a way that will get us to a better place than we are right now. But there's all kinds of challenges in trying to implement those well-intentioned ideas. So getting a working definition, I would say, is important to start with the notion of vulnerability. So we think about climate refugees. Some of them have already experienced that forced displacement, and the vast majority, though, are in imminent danger of that threat. It's going to happen soon, and we just don't know how soon. So vulnerability is an important starting place when we think about defining what we mean by climate refugees. And it's about getting pushed out of what you call home because of climate change impacts. And if you're thinking ahead, you can already start to realize that it's probably going to be difficult to say who's been displaced exclusively by climate change impacts. You know, there's probably other forces that go into how displacement works, and it might be primarily because of climate change impacts. There might be a severe food or water insecurity situation that pushes people out, but there may be other underlying forces that also propel that decision to leave. But the idea here is that it's not so much a decision, should I say, or should I stay or should I go, but more of you have no choice but to get out of what you call home, number one. And number two, home is no longer there once you leave. That it's not an option to return home, I think is an important starting point in thinking about what we mean by climate refugees. And we'll see that that's very different from a traditional notion of how refugee is defined under human rights law. So it's this idea of being vulnerable, being essentially pushed out from what you call home, and looking back, not being able to go back to what you called home. And then there are other layers of definitional challenges here. So when we agree that international law or whatever body of law should address climate refugees, are we talking about displacement that takes populations from one nation state into another, and that's when climate refugee protections would be triggered? Should it apply to internal domestic displacement, or should that just be the responsibility of that particular nation to address what displacement occurs within its sovereign borders? And then does it have to include permanent displacement, or would temporary displacement be addressed by a climate refugee legal regime? And an example would be the victims of Hurricane Katrina, many of which were pushed out of the 9th Ward of New Orleans, temporarily relocated in the Houston Astrodome or elsewhere west of New Orleans, and many of them came back to a different, but what they still called home. And the question is, would they be considered refugees, climate refugees, under a definition in a legal framework protecting refugees? So what's really interesting, though, is that this idea of how climate refugees are starting to be a concern has been in the international domain for a while. Way back in 2003, 20 years ago now, a very provocative statement by Tuvalu's prime minister referring to the developed world's failure to address climate change mitigation appropriately is essentially a slow and insidious form of terrorism against their people. And those are provocative words, and I think they're important words to frame something that seems like a harmless lack of ambition to do the best you can on something that is expected of you, and essentially criminalizing it to the highest degree, to label it a form of terrorism by not doing what you're capable of. For instance, in the US, not being a member of the Kyoto Protocol, or for a period the Paris Agreement, when the rest of the world is, with very few exceptions, and when you are the leading per capita emitter of greenhouse gases in the world. Yeah, I would call that criminal failure to fulfill a legal and moral responsibility. I'd call it a form of terrorism when you know the consequences are going to be propelling developing countries off of the map, out of existence, by not doing what you can and should do to regulate your own emissions. So I think that was a very important statement, and that's been an ongoing discussion. And there's now a big focus on the notion of ecocide as a form of criminalization of both action and inaction at the International Criminal Court. And so we might be at a level where a failure to address climate change appropriately could be ultimately considered a form of ecocide. And then we've got all kinds of migration that's already happening in areas where you don't want migration to happen. Food insecurity, water insecurity issues in areas of the Middle East, North Africa, South Asia, flooding, droughts, sort of climate change impacts that are going to push people abruptly out of where they call home and into where it's definitely not home. That's going to be really a flashpoint of controversy. So a picture sometimes helps illustrate vulnerability better than I can in words. So there was a major case in the US. This is a domestic case study that I'm going to turn to now, where a tiny community of 400 Native Alaskans, way up there at the north slope of Alaska, right at the top where it starts to slope downward. Very, very cold, remote area in the Arctic. And this is a community that lives on this narrow strip of land. And ultimately, you might think, why would anyone choose to live on such a narrow strip of land? That seems dangerous. Well, it wasn't always that narrow. This was climate change over a period of decades through sea level rise and coastal erosion, making that land, that strip of land, more narrow, more dangerous and uninhabitable. And this community was in need of relocating completely, setting up shop 10 miles inland from where they called home. And what was remarkable was the price tag associated with that, starting from scratch, building the infrastructure from the ground up just 10 miles away in northern Alaska. 400 members, the price tag was 400 million. And this wasn't some fancy consulting firm that came up with that estimate. It was the US Army Corps of Engineers, certainly not prone to inflate figures about what the cost of relocation would be. And that was a pretty accurate estimate. And you can assume that this Native Alaskan community of 400 did not have that money to relocate itself. And so it tried to turn to the law to find a remedy. How are they going to pay this bill? They know they can't stay here. They know they will literally drown in place if they don't get away from what they called home. And so they knew a lawsuit against the US government was not likely to be fruitful at that time, although just a few years later, there were a whole line of suits that were suing the US government for their failure to act on climate change, and those have yet to prevail, but it wasn't even on the radar back then to sue the federal government, regardless of its likelihood of success. Certainly, the state of Alaska was not going to be a defendant. Sarah Palin was the governor at the time. And so what does that leave? Well, that leaves the multinational fossil fuel companies that are significantly contributing to this global problem that is reaching northern Alaska as well. And what's remarkable about the statistics related to those major multinational oil and gas companies that were sued in this case, just 24 of them. And there's a statistic that it's just about 75 of these major multinational corporations that account for 2/3 of global greenhouse gas emissions in the world. So that really kind of changes the calculus that we might be engaging in when we think about who is responsible, who should be contributing toward the solution for global climate change impacts. Well, those figures are quite telling. So that group of defendants was sued in this litigation and sued in many other creative common law strategic litigation scenarios in the US and elsewhere. And not surprisingly, this case did not prevail. It was quite challenging even to establish standing to bring this case, because it was a causation issue. And the good news is that this case was brought in 2005. Here we are just less than 2 decades later, and this field known as climate attribution science has evolved significantly so that it helps plaintiffs who bring these kinds of cases. The idea of climate attribution science is linking specific entities' emissions to specific climate change impacts. And that is much more definitive now than it was 20 years ago. So when this case was brought, you can imagine the attorneys for ExxonMobil pointing to this map and saying, there is no way to connect my client's emissions to that sea level rise in North Alaska. And they were right. Back then, scientifically, that was a major causation hurdle for the plaintiffs to say that there was some way to link these defendants directly to this sea level rise that was causing this threat of displacement. And now science is helping us make that connection more definitively. But regardless, the village of Kivalina here has really still 2 decades later struggling to find solutions to how it's going to find a safer place to live in light of these threats. So we talked about standing being a hurdle. Another big hurdle in these cases, the political question doctrine. Courts have ultimately concluded that these cases that are trying to ultimately determine that climate-related relief should be afforded, courts say, well, this is really the job of Congress. This is the job of the executive branch. This is not for the courts to determine who gets a climate remedy. We have the Clean Air Act. If you want to create climate relief, you should go through our existing federal legislation. You shouldn't ask the courts to make law about who wins and loses on climate change impact assessments. So, and when we talk about causation to even get into court with standing, then you've got an even higher burden at trial when you try to bring one of these cases and prevail to seek relief for climate change impacts, because the burden at trial, as you know, is higher. So that's where we are right now in one of those cases that did sue the government on a climate justice relief theory. It's called Held versus Montana, and it's one of the cases that were on the coattails of the major Juliana litigation in the US. Teenagers bringing lawsuits against both the federal and state governments in the US, seeking to compel the government to do something more when it had not done enough, or to act in the first instance if it had chosen not to act on climate change. So one of those cases now proceeding to trial. It'll be very interesting to observe. It's going to trial this June. And it'll be very interesting to see just how high that burden is for them to establish that they have met their burden of proof at trial to show that they deserve the remedy they're seeking there, in which case it's only declaratory relief in that case. But even that is very important for a court to ultimately come down and say, Montana has violated this constitutional protected for a right to a clean environment by failing to do X to facilitate, in their effort to facilitate this fossil fuel driven economy. They are violating a constitutionally held right to a clean and healthy environment. So one thing that's important to think about is this idea of how the law is not equipped to help these vulnerable communities get out of harm's way before they are victims. So when you think about FEMA, Federal Emergency Management Agency in the US, their authorization is only to go in after disaster strikes. If you think about all the criticism that came down on FEMA after major storm events, whether it be Hurricane Katrina or elsewhere in the US, the reality is that you can't blame them that much because their capacity is so limited. I mean, it's really just a damage control mandate when you talk about responding to a terrible climate-related disaster, essentially throwing life preservers to people who are already drowning. What the law needs to do is to be able to get out in front of these issues and do vulnerability assessments of populations and authorize the law to take people out of harm's way before disaster strikes. That's the world we're looking at in the next 50 years. And if we care about protecting these vulnerable populations, that's one way the law can do a better job. And you may think I'm dreaming, but that's not unprecedented. There are other examples in the law where there is a threat of an imminent challenge, disaster. The law does authorize taking communities out of harm's way. And one that you might be familiar with in the environmental law field is CERCLA. So when there's a threat of imminent contamination of a community related to hazardous waste, there is going to be an authorization to move a community away from that threat so we don't have another love canal, which was essentially what inspired CERCLA way back in 1980. There was a major toxic contamination of a community. That is something that we can avoid if we have the right legal measures in place. So this has also happened elsewhere outside of Alaska in the US. There was a very limited grant program where the US government was offering communities that are vulnerable to apply for a grant to facilitate their relocation. Very, very tiny, limited amounts of money, but a very tiny community in Louisiana was able to benefit from it. Again, indigenous community, again, very small, about 60 people. And again, the price tag was almost $1 million ahead, 48 million to relocate 60 indigenous community members out of harm's way in Louisiana. But if that's the only thing that the federal government is offering, that's a pinprick response to the onslaught of displacement that is awaiting us. So that's important to remember, that there's so much more the government can do and needs to do to get ahead of this crisis, because it's literally going to be picking 1 out of every 10 communities at best after the fact to try to do something. So at the international level, a very famous case that really shone a light on this vulnerability and displacement concern was the Inuit petition before the Inter-American Human Rights Committee. Also around the same time as the Kivalina case in Alaska. And what was really compelling about this case was how it framed this climate change impacts as a human rights problem, because we weren't speaking in those terms. And this is just less than 20 years ago. It was environmental laws here and human rights laws here, and this case kind of married those worlds in a very compelling way. And even though the petition failed, the Inter-American Commission concluded that there's no basis on which to grant relief to these indigenous inhabitants throughout the Arctic, primarily in Canada in this case. It was really instrumental in connecting these two worlds in a powerful way to now move forward with. So all of these existing human rights were fashioned into this environmental context that essentially the melting Arctic that was being propelled by the US's failure to be a member of the Kyoto Protocol to regulate climate change. The argument was that it was collectively a violation of all of these human rights that the indigenous community had. And collectively, they were referred to as a right to be cold. That didn't exist under international human rights, but that was the formulation that the advocates made here in making this argument linking climate change impacts and human rights, that essentially their entire way of life was being destroyed as it melted away before their home melted away before their very eyes. And the suicide rate among Inuit teenagers skyrocketed at this time because they were seeing their elders leave for hunting and fishing trips and never returning because of the vulnerability of all that melting Arctic that was happening at such an alarming rate, the permafrost, the sea ice, everything that they called home and how they defined themselves. So it's very difficult for the law to provide a remedy when you've got communities that have no interest in moving from where they call home. There's a limited amount to what you can do. We're not going to relocate the Inuit or the Kivalina community to Kansas. That's just not something they're willing to consider. They'll die in place. And so a lot of these remedies are very short-term and not fully effective because we've gotten to such a level where it's a crisis that's already ahead of us. So we have to think about what the law can do to address some of these challenges in a way that respects and serves these vulnerable communities to the best extent possible. And of course, if you're trying to seek any kind of relief under international law, it's even harder than the nearly impossible route that we went through under US law. Many more obstacles are in the path of those trying to seek relief under international law. A very positive and recent example that I encourage you to read about, though, is the Torres Straits Islanders and their ability to successfully have a court recognize that their human rights were violated with respect to Australia and Australia's management of climate change and the impacts that it caused in the Torres Straits. So that's one hopeful sign, but nonetheless, it doesn't afford a lot in the way of concrete action or remedies. It's a very important first step, though. So back to human rights law, the idea here is that we have an existing definition of refugee, and it's nothing like what we're seeing with climate refugees. So this highlighted red language is what international human rights law has to say about what a refugee is. And when you look at this language, this has nothing to do with climate refugees. We're talking about a fear of persecution based on a variety of factors that makes you want to leave what you call home, not because you're forced to. You're making a decision that this is an inhospitable place. I'd prefer to live somewhere else. And you are unwilling to go back to that inhospitable home. Not that you can't go back. You're making a choice to leave and a choice not to return. Climate refugees do not have either of those luxuries. They're not making a choice to get out of what they call home, and they don't have a choice to return because home is no longer habitable. So there's no way to shoehorn climate refugees into this definition without really just completely overtaking what this treaty is meant to protect. I mean, there's an existing class of refugees that deserve this human rights protection. Climate refugees is something entirely separate and really not amenable to amending this treaty's protections. And then you've got another international law challenge compounding that. When you talk about states in the South Pacific, for instance, you've got international law defining what it means to be a state under with these four elements. And when you think about how climate change impacts are affecting these vulnerable states, they could easily fail to meet all four elements here. When you think about an island nation that has gone underwater and it's no longer habitable, does it lack a territory? Does it lack a population? There are arguments both ways here. That population still exists and it's looking for a new home. So arguably the population hasn't been exterminated. It's probably been thinned a bit from the threat of these climate change impacts. And an argument can be made that the territory is still there. It's just much more wet than it used to be. So there are creative ways to say that the state should not dissolve under international law, but where it goes next and how it will be recognized is a big challenge. You can imagine a South Pacific island nation having to go to Australia or New Zealand and not being welcomed with open arms, that we've got 30,000 people who just have to land here or they're going to die, and they're now still able to maintain their nationality in a new place. They're likely going to be required to nationalize as Australians if they're going to land on Australian soil, and that's not something that's in the interest of this displaced Pacific island that has a very strong sense of identity. So that's a huge challenge in how this state of international law might respond to protect those vulnerable nations. So the options are pretty limited when you think about how international law can respond effectively. We talked about how there's no way to really amend the existing human rights treaty. When we talk about climate change and how slow things have moved generally to govern climate change as a threat, it's very unlikely there's going to be time to effectively add some kind of amendment or protocol to a climate change treaty system that will address climate refugees. So what we're likely looking at are very piecemeal efforts to fund where there is need to assist those who have to migrate. And that's what we've seen in a lot of situations under international environmental law. A lot of times it's just throwing money at a problem and seeing how many people can be helped. So there will be a lot of challenges here to ultimately provide some kind of framework. My thinking is that these situations are likely going to be governed at a regional level because there are different challenges from region to region, depending on what sorts of climate change threats you're facing and the existing legal systems in each region. But certainly it's not going to happen without funding. So just an example of how cheap the developed world has been in trying to address these crises in the developing world. The US is being asked to contribute about 10 billion a year to this global climate fund that's supposed to help adaptation in the developing world. 10 billion sounds like a lot of money. They have balked at that money for meeting that expectation for years, even under the Biden administration, but under Trump, forget it. Not a penny was going into this fund. The expectation was 10 billion a year from developed countries. And just to give you a sense, Hurricane Katrina alone cost us about 40 billion. And so US is watching the developing world go underwater on its watch and is unwilling to put up a fraction of what it put in to save its own people, and is refusing to put a similar contribution, a lower contribution, to help the rest of the world that it has significantly contributed to imperiling with its own actions and inactions on climate change. So that's a real troubling scenario. I would also suggest that thinking creatively outside in an interdisciplinary way, laws on immigration and asylum will also need to come into play here and perhaps be modified to reflect this new reality about people who have to move somewhere else and need some protection from the law, even if it's only temporary. We have a category called temporary protected status, TPS, under US immigration and asylum law. That might be one category that would apply to those that have to find a safe haven temporarily until they figure out what's next. So we certainly have to at least do that much to work with what laws we have to afford some degree of protection to those who are displaced. Funding options, I would remind you how easy it is to get this kind of revenue at the federal government. Most of you don't realize when you fill up your car at the gas pump that you're paying a significant amount of tax on every gallon of gas. It's invisible to you. You just pay the price at the pump, but there's some degree of, I don't know, 5% maybe of what you're paying is taxes, and a tiny carbon tax just at the gas pump, nowhere else in society. If that were applied, it would be absolutely invisible to consumers. They wouldn't say, no, I'm not getting gas today because there's a 2-cent carbon tax on my gas pump today. But that money in 1 year alone could raise billions in the US Treasury to address this very problem, to have the funding that is seemingly so hard to provide. It would be available without anybody really feeling the pinch about generating it. So there are creative solutions available out there, and it's just a matter of having the political will and creativity to make those happen. But tax is a 4-letter word in the US, and it's very hard to get anything passed that is called a tax. So we're certainly running out of time to address this issue. The Biden administration has been more friendly to this challenge, although the best that it's done is merely recognize that climate refugees is a challenge. In a 2021 report, it didn't provide any kind of recommendations for relief responses. So that's better than nothing, but not nearly where we need to be. And as we look at all these tragedies unfolding around the world from climate change impacts, transboundary migration will be happening very, very often and in a very threatening way very soon. And so there's just a need to get out in front of that and ultimately ensure that the law is doing what it can in as many ways possible, not just through global climate negotiations, but being a little bit more creative about that. So I'll stop there, and I leave with this image because when I was in Glasgow, this was in the streets outside of the international climate negotiations, this 6 or 7-year-old girl out there protesting to make sure we get it right in those negotiation rooms. And I was just thinking back to my childhood, I was in the backyard playing football with my friends, not thinking for a moment about the security of my future. And here it is just in the span of my lifetime that this is what children are doing with respect to their climate compromised future and what climate refugee status might mean around the world. So it's a sobering thought, and hopefully inspires some way to respond to the issue while we still have a chance. So I welcome your questions and comments. Thank you.
Oh, there's some chats. I don't know what those are.
Yeah, am I supposed to see where we are with those? Okay. Yes, the question about whether the slides are available. Yes, they will be. Someone was getting bored and wanted to know how much longer the session was going to last. A helpful right to be cold reference to Sheila Cloutier who's that leader of the Inuit movement there. Union of Concerned Scientists is the source for a lot of that cutting edge attribution science. And there's a link to a report. Yep, just comments. So any questions? Yes.
You mentioned some of the lawsuits are not yielding the results that we would hope for. What change do you think that will take? Is it more creative arguments? Is it changes in the judges? What needs to change for that?
Yeah, it's a very good question. So I would say that what I've observed in the past 3 decades with these kinds of lawsuits is that if you want to be a good environmental lawyer, you absolutely have to have 2 qualities, and that's creativity and persistence. So these lawsuits, when they first are launched, fail miserably because it's trying to break new ground, and it takes a long time to break new ground. And you just have to stay the course and retool the theory, and ultimately it's going to stick. And so a great example of that was with the Juliana litigation. So there was an effort to sue the federal government prior to the Juliana case. It was called the Alex L case. And there was a different kind of legal theory that was used, and that was ultimately dismissed. It didn't hold up. And then there was just a new way of framing this case against the federal government for its failure to regulate climate change and how this was causing a violation of these teenager plaintiffs' rights. And so it was framed in a way that was more creative and breaking new ground. And ultimately that too failed, not surprisingly, because of its ambition. But that spun off more narrow and potentially effective ways to move the ball forward at the state level after those federal suits didn't succeed. And that's really where we are now. If those suits succeed at the state level, then we've got the potential for a valuable, impactful results that might not happen as soon as federal relief would have, but nonetheless will be very, very important in getting relief for these plaintiffs in terms of how the law can protect the interests of future generations in a rights-based kind of way. So I would say in some instances, you've got the wrong people on the court. In some instances, you've got the right people on the court. I'd encourage you to read the motion to dismiss the Juliana case in the District of Oregon. It was a judge called named Ann Akins, and she fully embraced the plaintiff's theory of relief. And it was just a brilliantly written opinion. And just the fact that it's out there, even though ultimately the case did not go to trial in the federal level, just the fact that one judge wrote an opinion the way she did is, again, a foundation for making this happen in subsequent cases. So similar to the Inuit petition, that was just a great framing of how we need to think about climate change as a human rights issue. Way back in 2005, a decade later, they would have never predicted the explosion internationally of successful climate change lawsuits around the world built on that theory that failed. So that's really how I would summarize it, is that where there's a will, there's a way in the law. It doesn't happen soon enough. It doesn't happen effectively enough, but some version of it will happen if you stay the course. And that's hopefully inspiration for those of you with your careers ahead of you, that it's well worth the effort, and expect a lot of losses before the wins come your way. Yes.
It's a similar question. I'm trying to understand where most international environmental attorneys are working. You know, we hear about the major lawsuits, the ones that create international news. And I understand that many of those are rare cases, but for the majority of practicing attorneys who are addressing issues like international climate change, who are they? Where are they working? How do they get there?
Yeah, it's a good question. There's more of them in the private sector these days, which is still good work. So basically, if you're advising corporations on how to comply and navigate international environmental requirements, that is still good work that needs to be done. And in fact, this this new era we're in of ESG, environment, social governance mandate, and how the private sector does its business is a real opportunity now. A lot of opportunities in the private sector to do ESG related work for companies and essentially build that sense of responsibility and compliance from inside where the most harm could take place moving forward. That's really valuable work. I'd say there's more public interest opportunities these days. Some major NGOs are starting to take on these strategic litigation opportunities. Those jobs are few and far between. Most of them are right here in DC. So you're at a huge advantage being at GW, an opportunity to intern with some of these places. The Center for International Environmental Law is one that certainly comes to mind at the top of the list. Client Earth. A lot of major public interest organizations have really made a significant impact in a short period of time, getting involved in these kinds of strategic litigation cases. So I would encourage you to try to get that experience while you're in law school, because it's very difficult to lateral into that kind of position. You kind of have to get in as early as you can and really build relationships. There's all kinds of lawyers who are capable of doing the work, but a lot of times it's about finding someone with the passion and commitment and the skills to come up through their ranks and be a part of that team and that cause. So I would also say that there's more awareness of this at the academic level as well. I think there's just a lot of advocacy happening among environmental law professors for this work. I've signed on to easily 24 amicus briefs that pertain to this kind of litigation in the US and outside the US. And I think there's just a growing community of interest to make an impact on these issues. And there's also more opportunity for both students and professors to engage in the actual climate COP negotiations and related proceedings. So you have some kind of ability to observe and influence process that's so important. Yeah, Jerry?
I was just wondering, as the science continues to evolve and the modeling gets better, and discovery of things like ExxonMobil and what they knew about climate, do you think this will strengthen the case for making the cases stronger in the court?
Yes, absolutely. So the science and the awareness, the growing awareness of what the private sector knew and disregarded with respect to climate change impacts, that's the subject of litigation all over the country now. And in those cases are proceeding to trial as well now, which is really exciting because that's essentially the ultimate airing of dirty laundry for the public about what the fossil fuel industry knew about climate change, how they acted in disregard of it, and worse still, they actively engaged in disinformation campaigns to the public about the relationship between fossil fuel use and climate change. So there's all kinds of lawsuits that are seeking all kinds of common law relief for that misbehavior. And there's a whole new wave of industry response to that threat, which is now called climate washing. And I'm writing an article on this phenomenon now, which is both governments and private sector entities trying to convey that they're doing better than they really are in terms of complying with climate change governance expectations and characterization of products that are supposed to be good for the environment, good for climate change when in fact they aren't. So yeah, the writing is definitely on the wall that there's a lot of accountability on its way. It takes a long time. But ultimately, when you think back to the BP oil spill, the private sector can pay its way out of just about anything. And so that's where I'm encouraged to see more discussion about criminal responsibility for this kind of behavior. It's not just pay the bill and move on and with business as usual. This has to be something that pushes them out of business on a variety of levels. And that's how we're going to get to fossil fuel phase out. They're not going to do it by choice. They're going to stay in the business as long as they can. And that's what business is about, to remain profitable in any way that you can. And so I think we're seeing how some of the prior phases of litigation in other contexts might be a precursor to fossil fuel phase out. We've seen it succeed with asbestos and lead paint and smoking, the tobacco litigation, opioids is even the relevant context. So we're seeing a similar pattern of conduct and a similar pattern of efforts to hold these entities accountable. And ultimately, they all won. And I'm confident that will be true with the fossil fuel industry as well. Yes.
Yeah, I have a question. So I'm curious, I know that the US has ratified some of the major international human rights instruments. And as a result of that, I feel like litigation on the basis of human rights might be a little bit more difficult to bring in the United States. So I'm curious what you think some of the most effective types of legal claims and avenues would be domestically.
Yeah, you're absolutely right about the human rights avenue. So the US is very much in its own league. It's not a fan of international law, so it's not a member of the International Criminal Court. It's not engaged on international human rights governance in any meaningful way. So basically for US accountability, it's very much been a function of creative common law theories that we have no choice but to use, because even at the federal legislative level, we've got this robust set of federal environmental laws that protect aspects of environmental issues, but not climate change. So it's been very difficult to find effective ways to use our existing federal environmental laws to get climate relief. It really has been much more about the creative common law theories. And that ranges from anything that you could think of, really. I mean, public nuisance, negligence, public trust, things that you may have studied in your environmental law electives. These are very much the tools of a creative environmental lawyer to find a way to get accountability for climate change impacts. And the list will go on. Hopefully you will add to it in your career that really anything goes until the courts say it doesn't. So it's a long list, and I've been very impressed with the range of theories that I would have never guessed might stick, and some of them did. Other questions? Let's see in the chat here. Question about the academic debate surrounding the term climate refugee as opposed to climate migrant. Some scholars argue that using the term refugee dilutes the meaning of the Convention on Refugee Status, whereas others state that climate-induced movement is the result of indirect state persecution and should be labeled as refugee movement accordingly. What do you make of those arguments? Yeah, I think those are very important distinctions. As I mentioned, how we define this term is going to dictate how the law might be able to afford protection. And I'm not a fan of the term refugee. It's just a placeholder. I think climate refugee as a term might do more harm than good when we talk about protecting those displaced or threatened by displacement on climate change. So I think framing it in terms of migration or displacement is probably a better way of characterizing what the law might be able to do. And I think that's just going to be an ongoing debate. But yeah, I'm almost inclined to stop using the term refugee because it's what people can relate to. So that's why I still use it. And there's even organizations that work on an international level who use the term climate refugees as the name of their organization. So it's kind of that growing pains period about how this is ultimately going to play out. So it's hard to say one way is better than the other. It's just important ultimately to have the conversations in as respectful a way as possible. And then there's preventive evaluation of U.S. environmental law. There are examples of shifts in the law towards prevention. Yeah, so this question pertains to my reference to having the law work in a way that gets folks out of harm's way before disaster strikes. So I made that reference to CERCLA, a very limited provision where there's an opportunity for relocation of communities that are in danger of an imminent threat of toxic contamination. And then there was another example elsewhere outside the US about a threat of a potential mudslide, and ultimately a law that authorized getting the community out of harm's way. So I think it is about just finding ways for the law to restructure based on this Anthropocene reality that we're living in. And this is going to be one of those big new things that ultimately the law has to respond in a way that's based on vulnerability rather than something that's already happened, because something that's already happened is going to be so catastrophic and so impossible to ultimately correct or even diminish that it just makes no sense for the law to respond after the fact when we're talking about climate change emergencies like we're facing now. Yeah, so there's another question that we've already discussed about the awareness of the the fossil fuel industry's knowledge on climate change and the disinformation about it, and that's really gaining traction in the courts in the US now and elsewhere. I mean, it's been really positive in the Netherlands in particular. I think some pending cases there on climate washing and so forth. There's a question about foreseeability, which I think is a very good one, and one that I think the law can also build into its calculus about how to address these issues. So one example I would give in that regard is that NEPA, the National Environmental Policy Act, there's a body of case law under NEPA that looks at, would those preparing an environmental impact statement have to consider the impacts on climate change that a particular project might have? And that's the kind of forward thinking we need. A lot of courts are saying yes. And that's really powerful thinking, because it can essentially translate well beyond NEPA. And there's a major case that recently came out of Australia, New South Wales, where a major proposed coal mine was ultimately not granted a permit, in part because the judge determined that granting that permit would take Australia out of its carbon budget if that permit were granted and that major coal mine were allowed to extract and create all those emissions, whether they were exported or on Australian soil. So I think that's a new way of thinking that we also have to embrace more fully, is this idea of what it means to be sustainable. I mean, if we're serious about sustainability as a mantra for how we live, we have to start declaring things that aren't sustainable and penalizing them or not allowing them to occur. And I think there's a lot of movement that way on many levels of governance. And I think the law has some handles there to help us reach that goal sooner than we might on protecting climate refugees. So yeah, these have been terrific questions, great dialogue. Happy to continue the conversation. I'm not sure where these slides would be posted for access. So those of you on Zoom, I encourage you to perhaps email me if you'd like to have a discussion or receive the slides or continue the dialogue. I see someone, Manish, has his hand up. You can go ahead and ask your question.
Good afternoon, sir.
Yes, I can hear you.
So my question is, when you told about the issues regarding jurisdiction, one was causation.
Yes.
When we read about the principle 16 under the Rio Declaration, it provides about the polluter pays principle. But the current trend, like being a student of international criminal law, I find that it has turned into a criminal antecedents are coming out, like the recent events in African continent and other parts of the world. That means it's not just an environmental issue, but it's furthering, like evolving into armed combat issues also. Now, how do we fix the liability? I'm talking about the criminal liability, because I don't find any law which specifically deals with it. Thank you.
Yes, I think that's a good question to ask, and not an easy answer to it. But basically, the question is the polluter pays principle, which is a general principle of international law that basically does what it says, that those that are responsible should pay for the harm they cause, and how this has both civil and criminal, potentially criminal dimensions to it. And when we think about holding polluters accountable, that this is something that has to be enforced more ambitiously and aggressively. And I think that I agree that the law ought to move that way. I think it is starting to when we look at the discussion around ecocide as a crime under international law. I think is a positive development in that regard. I also think that when we talk about accountability, even though the loss and damage discussion at the international climate level has not ultimately reached a favorable outcome for the developing world, I think there is certainly movement where there's going to be pockets of relief for particular vulnerable communities in getting some kind of compensation for polluting with respect to climate change. And I think there's a growing consensus about protecting indigenous communities throughout the world as vulnerable parties who will be entitled to that compensation perhaps sooner than nation states would be. But it's a very slow process. And I think it's, again, this process moves at a snail's pace. International law is very difficult to make and even more difficult to enforce. And I think one encouraging example would be, it took 10 years to get the UN Declaration on the Rights of Indigenous Peoples drafted as a non-binding instrument. And now it's been adopted as binding legislation in Canada. And so I think that's really encouraging when we talk about the opportunity for the aspirations to ultimately yield concrete results. So very, very much a work in progress. So a very important question to ask, and hopefully some solutions will be unfolding in the not too distant future there.